The day I found out someone was trying to take my house, I was standing barefoot in the kitchen holding a cup of coffee that had gone cold, the kind of cold that makes you wonder if the day knows something you don't. The letter sat on the counter like it owned the place. Notice of intent to foreclose, big, bold letters, as if someone wanted a dramatic entrance. I remember laughing once out loud because it had to be a mistake. And then my hands started to shake. My name is Margaret Whitaker. I'm 72, widowed 4 years, and I've lived in the same 2-story brick house on Cedar Lane for nearly 20 years. It isn't a mansion. It's the kind of house that remembers you, the dent in the banister where Daniel bumped his elbow, the sun-faded spot on the kitchen floor from years of his newspaper. We paid it off years ago. Every nail in that house knows my name. So when the letter said I owed $9,840 in HOA fees and penalties, and that I had 30 days, or they'd foreclose something in my chest, went quiet and serious. Pine Hollow Estates is not ritzy. 200 modest houses, trimmed lawns, 4th of July potlucks where you bring potato salad and fake a little pride, neighbors wave, exchange pie recipes, don't know each other's middle names. The HOAA minor irritation. Reminder emails about trash cans, the occasional passive-aggressive notice about hostas, the Facebook group run like a PTA with a whistle. The president was Carla Jennings, early 50s, sharp bob, always looked like she might pivot from a neighborhood meeting into a corporate merger. She ran the group like a courtroom, and she wasn't shy about shaming people publicly. I'd never had a problem with her. I had in fact paid my dues like clockwork, quarter after quarter checks mailed on the 1st. So I dug out the filing cabinet and laid everything across the dining table. Bank statements, canceled checks, 14 months worth, neat and legible. When I called the number on the letter, Carla picked up on the second ring, crisp as a postcard. Pine Hollow, Hoy. This is Carla. I said, this is Margaret Whitaker on Cedar Lane. I just received a foreclosure notice. There must be a mistake. Her pause had the shape of a sigh. Mrs. Whitaker, she said with that thin, practiced patience, our records show you've been delinquent for 14 months. She chuckled, actually chuckled, and told me older people sometimes forget. People your age, she said. I felt something clamp inside me. Before retirement, I spent 25 years on the State Court of Appeals. I didn't wear the old title like armor, but I knew the difference between sloppiness and intention. Foreclosure isn't an administrative hiccup. It's a legal nuclear option. I started asking around quietly. Tom, who walks his golden retriever past my house every morning, mentioned he'd gotten a weird notice about landscaping fees. A young couple down Maple Ridge had been threatened with a lien over an architectural issue they swore they'd already fixed. Things that look random start to look arranged when you know where to look. I requested the board minutes that authorized my foreclosure, formally citing statute calm and professional. Carla sent a scanned PDF 3 days later. If you're not used to official records, you'd miss it. But the formatting was off. The language had a manufactured quality. A unanimity vote recorded even though 2 named board members had moved away months earlier. I remember delivering a casserole to one of them when his wife had surgery. Focus came back to me the way it used to in chambers. This smelled like more than a missed check. This smelled like power. So I hired a forensic accountant, David Clean, a neat, obsessive man who color codes spreadsheets the way some people collect stamps. I asked him to audit the HOA's finances, fee collections, enforcement actions, 5 years worth. He called me 2 weeks later, tight-voiced. There were discrepancies, and they were not small. Funds from late fees and foreclosure costs were routed through a vendor account tied to a property management company, a company partially owned, David found by Carla's brother-in-law. Over 4 years, the diverted totals stacked into the tens of thousands. You hear people your age forget, and you think it's about memory. In Carla's case, it was a weapon, a dismissive little line to make me seem feeble, to make the panic easier to buy. When David showed me the trail vendor payments, a company called Evergreen Compliance Services that handled collections and legal processing registration to a tiny office 20 minutes away, I stopped thinking clerical error and started thinking scheme. I began to talk quietly to neighbors. Mr. Alvarez, who'd paid a $5,000 settlement because his wife was sick and he wanted sleep. Jasmine, a single mom, who'd paid $2,000 to avoid a lien over a shed approved years before. Each story added a layer of pressure, of calculated intimidation. When the 30 days passed, Evergreen filed a foreclosure action. The complaint painted me as negligent, as though I'd spent a year shirking responsibility. I remember sitting with the paperwork on the kitchen table, careful with the edges like some fragile truth. Being sued rattles your bones even if you're right. I filed an answer pro se, denied every allegation, attached 14 canceled checks, bank confirmations, a sworn affidavit that no valid board vote had authorized foreclosure, and filed a motion to compel full production of HOA records, including internal emails. Carla hired an attorney with the kind of rapid-fire procedural language that hopes to swamp you. At the preliminary hearing, his smile was the prelude to a suggestion: settle. Litigation is costly, he said. I said plainly, fraud is very costly. Discovery began. Emails slipped out like leaves in a wind. That one from Carla to Ryan, her brother-in-law, said, "Push Cedar Lane forward." She won't fight it. Older homeowners always cave once the legal notice hits. Cedar Lane is my street. When I read those words, I felt that old courtroom clarity, the part that makes your pulse go slow because the structure of the wrongdoing is finally visible. David traced Evergreen's invoices, the padded legal processing fees, the ghost charges routed back as consulting reimbursements into a discretionary HOA account. $72,000 misallocated over 4 years. Numbers on a page, yes, but each dollar told a story about someone bullied into paying to stop the noise. Settlement checks signed in shaking hands, quiet compliance in the face of official papers. The hearing for summary judgment came in mid-October. I dug a navy suit out of the closet pearls my mother used to wear, and for one morning I borrowed the spine of my former life. I could have said retired. Instead, I said, retired Associate Justice of the State Court of Appeals. The air shifted. Judge Harrington listened. When I walked the court through the canceled checks, the statutory requirements for HOA foreclosures, the forensic report tying vendor payments to Carla's relatives, the judge's pen stopped. He asked why 2 board members listed on the recorded vote had resigned prior to that vote. Carla's attorney muttered clerical oversight. The judge looked harder. The court denied the plaintiff's motion for summary judgment and referred the matter to the district attorney for potential financial crimes. It was a crack in the dam. Once the DA's office got involved, the quiet things became subpoenas. Bank records, interviews, closed-door meetings. Pine Hollow went from manicured lawns and polite waves to whispered conversations at mailboxes. People who'd never said a word started showing up at meetings, holding copies of financial statements like talismans. The DA charged Carla embezzlement, wire fraud, forgery, alleging $74,300 misappropriated in improper foreclosure filings against at least 9 homeowners. The indictment turned rumor into record, and when record exists, things move. The criminal trial was methodical. The prosecution played the emails in the courtroom like exhibits in a gallery of intent. Push Cedar Lane forward. Older homeowners always cave. They showed how Evergreen billed for phantom services and how money circled back. Carla testified and blamed the management company, said she relied on recommendations, claimed she was overwhelmed. But under cross, the paper trail twined around her. The verdict came back guilty on major counts, no theatrics, just a long, emptied exhale. 6 years in state prison, restitution ordered in full. My civil suit awarded repayment of the fabricated balance, emotional distress, legal costs, punitive damages sent intentionally as a message. Carla was removed from the board. New leadership, independent management, quarterly open financial reviews. Attendance at HOA meetings tripled. People started reading line items aloud. The same folks who once ignored an email now asked where every dollar went. Some neighbors grew distant. Others quietly thanked me. One woman who'd never spoken more than hello at meetings came by while I trimmed the roses and said, awkward and bright, "If you hadn't fought, none of this would have come out." Was that gratitude, accusation? Maybe both. The truth is, when you expose rot, you unsettle the whole tree. A year later, Cedar Lane is different, not tense, just awake. Meetings run long, questions are sharper. We have transparency baked into the process. I'm back to the garden, the book club, the slow mornings with the good mug. I still think about that first phone call people your age forget. Maybe the real danger isn't age, it's assumption. Carla assumed I was isolated, assumed I wouldn't parse records, assumed a threatened foreclosure would make me reach for a checkbook. She assumed wrong. If there's a lesson that slips in naturally, the kind you don't lecture but live, it's this: power without humility corrodes, and assumption is a quiet accomplice. The ability to find, to lean, even to threaten someone's home is not a small thing. It requires oversight, integrity, people willing to ask uncomfortable questions. And never ever underestimate the person you think is easiest to overlook. They might be the one who changes everything. Justice felt satisfying in that slow legal way. It wasn't revenge. It was accountability papers signed, restitution ordered, a sentence that matched a pattern of exploitation. Carla lost her freedom. Homeowners got some of their money back. The neighborhood finally learned to read the books instead of trusting the cover. That doesn't fix everything. There are still neighbors who won't look me in the eye. There are still quiet costs you can't replace. But the outcome forced reckoning, and sometimes that is the only kind of repair a place needs. So tell me, if you were in my shoes, would you have paid just to avoid the headache, or would you have fought knowing it might fracture your community? Do HOAs protect neighborhoods, or do they sometimes become instruments of power that go unchecked? Drop your thoughts below, share your stories. I read every comment, and if you think accountability matters, even when it's uncomfortable, pass this on. Somebody out there might need the reminder that the person they count on to cave might just be the one who changes everything. And that sometimes the quiet, persisting thing called justice shows up right when people think it's too late.
Cảm ơn các bạn đã xem video.